like to introduce Christopher Yoo, who will be presenting legal implications of recent developments in RPKI. Christopher is a professor of both law and computer science at the University of Pennsylvania and is joining us here today in person. This is Christopher's fourth time presenting at NANOG, and it's a pleasure to have him speaking with us today. Welcome, Christopher.
Well, thank you very much. So this has been a project that's been a bit of a labor of love, and to me is a great example of the community, industry, ARIN, and the government all collaborating to getting a result and actually making a lot of progress towards promoting RPKI adoption. As some of you who've been at previous NANOGs, this is it's updating work we did in 2018 under an NSF grant I did with another colleague named David Wishtick, who's now teaching at Georgetown. And really, it's to update you on the problems we found in that report, and just to run them down. And then to evaluate the changes to the replying party agreement done in October 2019, twice in September 2022, changes to the registration services agreement to tell you to the extent to which they've addressed those concerns. And I'll tell you right now, these slides are already obsolete. In fact, ARIN made an additional change to the RPA dated yesterday, which I'm happy to share with you, that in my mind addresses even some more of the issues remaining outstanding. So what the issues we identified in the report, we identified a series of barriers to RPKI adoption. First, there was there's a clause called the Prohibited Conduct Clause that says signatories cannot share information in a machine-readable format and can only do it for informational purposes. There's an indemnification clause in the RPA and the RSA. There's a property rights clause in the RSA, which asserts that ARIN is the property rights holder, or did assert at the time. In fact, there were perceived to be barriers, and this is, to me, the most important of them. Validator software was being shipped with only 4 of the RIR's validators preloaded, and ARIN's was not preloaded, because at the time, they did require it be, you go to their website and download it from there. There were choice of law and arbitration clauses in the agreements. And in fact, in our conversations with the community, they identified the need for additional information on ARIN's operational practices. And we became aware that there's a greater need of consensus among the community of what the best practices were to make sure that everything continued to function. And in particular, in events of outage of the certificate library, would different community members fail over properly as specified by RFC 7115 to make sure that we don't lose connectivity, because that is an eventuality we all have to prepare for. I will say that before I say anything else, I am not establishing an attorney-client relationship with any actor in the firm and in this room. And if this were legal advice, in the words of a friend of mine, it would be followed by a bill. And so as long as you're not getting that, take this as this is a research project on our part where we're trying to understand what the barriers are based on a census of reading the documents, comparing it to the documents in the other IRRs, but more importantly, also talking to members of the community to try to get a gauge on what really could help deploy RPKI. All right, taking these one at a time. The Prohibited Conduct Clause in its original form said ORCP and provided information may be shared with 30 parties solely for informational purposes and not in a machine-readable format. And we received some comments from this that, in fact, in addition to deploying RPKI in an operational sense, a great deal of information is shared by security professionals about events and different forums, and that is an important part of any implementation process, and that prohibiting that being shared in a machine-readable format was a major issue. So our recommendation was to change this to permit the sharing for informational purposes in a machine-readable format. And one of the first things that happened in October 2019, ARIN made a change to the RPA, which had dropped the prohibition of sharing information in a machine-readable format, but specified that it could not be used for network routing. And in a sense, that addressed the issues about sharing of information of event notification and other problems that you see. but at the same time, it specified that it couldn't be used for routing. So in that sense, we consider this a partial solution. And I'll bracket this because this partial solution eventually becomes a complete solution based on another subsequent change after 2019. So these are roughly in chronological order, just as a way to tell it. The other issue that was identified is a blanket indemnification clause. Originally, the provisions of the RPA said, you shall indemnify ARIN from any and all claims asserted by a third party in connection with what is online resource certification, PKI, ORCP services, ORCP being a defined term in the RPA. And this indemnification clause caused a lot of people considerable pause. We pointed out that it, in fact, you're indemnifying against all claims, even claims firmly under ARIN's control. And our recommendation was to shift this to a disclaimer of liability, which is something that's done in other contexts in different forms. And in fact, ARIN did make the RPA did change the RPA somewhat. In October 2019, they also made a change that allowed for an exception to the indemnification clause arising from ARIN's gross misconduct. This is some movement in a positive direction, but again, we still had a recommendation that it be taken farther to disclaimer of liability. But in October 2019, we regard this as a good sign and a part of an ongoing engagement with ARIN. So we have here on our scorecard, we have 2 partials as of October 2019. This is all pretty encouraging. The big changes started to happen in September 2022. And this is where the additions, the changes to the agreements, the relevant agreements started to address the concerns we raised a little bit more directly. The original question of who is the property rights holder in IP addresses has been an issue for legacy resource holders because many of them had been assigned their IP addresses even in advance prior to ARIN's existence, and so that they regarded themselves as the holder. As part of the LRSA, the original drafting of the LRSA, the Legacy Registration Services Agreement, the LRSA included what's called a no property rights clause. And so it said the holder of the IP address agrees that the IP addresses are not property and that the holder will not acquire or assert property rights in IP addresses. And this raised a number of concerns. Certainly, legacy resource holders believe that they were the owner of the IP address and that it was property. A number of government entities expressed concern that they were not legally able to sign this because of changing the status of potentially government property. And what struck us is that this was an issue that was, in fact, a separate issue that was not part of the RPKI debate. And in fact, as you probably know, legacy service holders, they were grandfathered into the services as existed at the time ARIN was founded, so they could continue to receive those services without signing the LRSA, but to receive additional services, they would have to sign an additional document. And so our recommendation was to do something that RIPE has done, which is decouple the issue of RPKI from the issues of intellectual properties in the rights in the IP addresses. Important issue, agreedly, but not the same one that we're dealing with here. And so what was, in my mind, a very salutary development, in September 12th of last year, ARIN amended the LRSA to say that the holder agrees it acquires express contractual rights to the IP addresses by virtue of the agreement. So this basically acknowledges that in signing the LRSA, you are agreeing to certain things covered in there, such as we talked about the indemnification, and we'll talk about the other clauses, the choice of law clause. There are other specific requirements, but it makes no claims at this point either way about the property rights in the IP addresses, effectively decoupling the two issues. So now the focus is on the other terms in the RSA, but takes out the intellectual property issue, the property rights issue from this agreement, from any decision to whether to sign the agreement or not. Which again, in our mind, effectively decouples the issues in the ways that we recommended. Wasn't exactly the way we recommended, but it was very effective. So in this case, we believe that this addition, separating the issues of property rights and the IP addresses from the larger adoption issues, we think has been completely addressed by this provision. Now, the next is in the middle, but so it's sort of misleading. It's probably the most important issue we identified to RPKI adoption, which is, could validators ship their software with the ARIN TAL preloaded, in addition to the TALs provided by the other 4 RIRs. And in fact, there were a number of issues around this. This was identified as the most important issue. As I mentioned earlier, ARIN did require downloading its TAL from its website, and the rationale was by downloading it from the website, you could establish a contractual relationship, what we call a click wrap contractual arrangement, that by clicking, you agree explicitly to the terms and conditions, and it establishes a contract with affirmative assent, which would not have existed otherwise. And what we saw was there was some resistance to this idea because certain implementations became harder to deploy. And if each instance had to be agreed to, this becomes harder and harder. There were a number of concerns about this. And so ARIN made an initial policy change, which is it said that inclusion of RPA acceptance could be incorporated into the acceptance process for downloads. And so by clicking and including in your acceptance of the terms and conditions of a download, you could include acceptance of the RPA. And this did address certain concerns, did allow some people to begin to implement this. It took a while, but we found out in discussions with ARIN that people have begun to do this. And so in particular, if you're using proprietary software, you can do this. It tends not to be the case with open source software. Open source software tends to be downloaded directly from GitHub, and you rely on the license terms which automatically pass with it to do these things, in which case there is no necessary click acceptance on the software installation that can incorporate the acceptance terms of the RPA. So we have something that's been progress in the right direction in October 2018, fairly early. What's interesting is in September, there were a couple of developments that really changed the landscape here, which is the original provision had a prohibition of redistributing ARIN's TAL or sharing ORCP provided information with third parties for network routing. So this would clearly, if you're going to use the TAL, you're going to use it for routing. This was a major issue. Well, what was interesting is our recommendation is to remove that prohibition from use of RPKI, in particular the TAL for network routing. And the big question, the big liability question was, without a contractual agreement, what would happen if the certificate library went down? If things failed over properly under the RFC, you get 3 states: not found, found valid, found invalid. Not found is supposed to fail open. That is without disconnecting the network. And the concern was always if it fails closed, the outage of the certificate library would in fact disconnect parts of the network because there would be a problem. And so one of the things that they were that ARIN did, somewhat unusually, is they announced that they would do a random test outage of the certificate library at some point last summer, to find out, as a stress test, to find out how well configured different ISPs were for failover. And what they found is that we never actually got to the question of whether people had correctly configured to fail open, not found to open. What happened is they found that the validators relied on cached certificates for 24 hours. So if that's the case, any failure less than 24 hours, so long as validators are configured in this way, will not disconnect the internet. It'll just revert to the existing cache state. And so in this case, from an ARIN standpoint, from my discussions with them, this put a risk management boundary around what they could undertake. And they're aware that with the validators configured this way, outages of less than 24 hours were very unlikely to cause the network to get disconnected. And so at this point, they felt more comfortable, and they made a couple of changes. So the first one happened on September 26th. They created a new Section 9 at the end of the RPA that said, notwithstanding the foregoing, you may make available RCP provided info in a machine-readable format if the recipient has A, signed the RPA, or B, signed a contract that basically incorporates the same terms as the RPA. Now this still requires people to sign contracts and engendered a fair amount of pushback saying this is not fully addressing the problem. And 3 days later, ARIN did another adjustment to the prohibited conduct clause of the RPA that said, notwithstanding the foregoing, you are specifically allowed to publicly distribute the ARIN TAL, including by embedding the ARIN TAL in relying party software. So irrespective of Section 9 as creating one pathway for developing this, Section 5 now contains an explicit term that creates a new pathway. And this was a material change that actually had an impact in the market. After this, a number of the validators, at least 3 that I'm aware of, started shipping their validator software with the ARIN TAL preloaded. And so from the standpoint of in terms of getting real-world impact, this seems to have addressed the problem from the perspective of a number of the validators, which is a very positive development. Now, I will say that I had a lingering concern about some of the language, and this is where it starts to turn. This is where I'm going to start to talk in a way that causes some people to hate lawyers, but this is what we do. And although I take the fact that Michael Bailey takes great pride that he's got lawyers in his team, because in fact, in this day and age, it's inevitable. Section 5 has 2 provisions. The one that they added says, notwithstanding the foregoing, you may publicly distribute the ARIN TAL. And it's followed by a provision that says you may not distribute ORCP provided info for routing. And you could read foregoing as referring to language that preceded it in the contract but not following it in the contract, in which case the new language saying notwithstanding the foregoing wouldn't necessarily exempt it from the second language prohibiting distribution of ORCP provided services. Now, I will say ORCP provided services is a defined term in the contract. I could go into the great details about whether that includes distribution of the TAL or not, and there's reason to believe it wouldn't. But this was all actually swept away yesterday by another change to ARIN's RPA, which is not reflected in my slides. So you're getting this in real time. ARIN changed the language, notwithstanding the foregoing, you may publicly distribute the ARIN TAL, to notwithstanding anything to the contrary in this agreement, you may redistribute the TAL, and including in validator software. And the breadth of that language basically forecloses arguments that the later Section 5 language would potentially bar distribution of the ARIN TAL and validator software. So in fact, you're getting it in real time here. This is information that of the level of engagement that ARIN has had with the community. And in my mind, that's as clearly as you can establish in the RPA the permissibility of distributing ARIN's TAL as part of the validator software. So skip that. So now we have the prohibited conduct clause, which only allowed sharing but not for routing, has been addressed. And I said that when I put these slides together, I put the footnote on there because the star on it, because some validators were clearly saying it was enough, but there was this lingering concern. That asterisk probably no longer, in my mind, no longer belongs there. It has now been completely addressed by the change issued last night. 2 other things that are going on. So as I mentioned, both the RSA and the RPA require choice of law clauses. They require it to be governed by Virginia law and require an arbitration clause. ARIN has a policy of waiving those clauses for government agencies that are prevented by law from accepting them. This policy, in our mind, was not as well known as we would like. And so, in fact, one of the solutions that ARIN has indicated its intent to do is to put up a new page specifically for government agencies to facilitate government agencies' ability to navigate that process. So I would call that pending, but again, something that is in process. Information about ARIN's operational practices. Members of the community said we need to know what the uptime requirements are, what the refresh expectations are. I was talking to someone earlier today. If you post a new ROA, how long will it take to show in the certificate library? All the things that you need guidance on to be able to understand your expectations. And what we saw is a need for more complete disclosure of operational practices and to improve this, the certificate statements, practices statements. And ARIN has taken a number of steps, a new service dashboard that allows you to see the state of your ROAs, updating a certificate practices statement, and conducting an audit of services. And in conversations with John yesterday, he shared with me some interesting developments, which is it's one thing to have ARIN to set up its operational practices in one way. But if the other 4 IRRs follow different ones, you're going to have to basically do one-offs on all 5 RIRs. And in fact, Randy Bush had published a paper where he had to do sort of separate APIs to actually pull all the information out. At the NRO, there is currently a conversation happening among the 5 RIRs to standardize their API, standardize the practices, to their refresh cycles, everything, so that you actually can get a consistent experience across all 5 RIRs. Because right now, my guess is you can live with any of these things as long as they're consistent and as long as you know what they are. And I think the RIRs have differences that aren't really based on any deep difference in policy. They just did them independently. And so what we're going to see is, as part of those discussions, the hope is better information about operational practices, not just for ARIN, but for all 5 RIRs, will emerge in a way that is harmonized and standardized that will facilitate the operation of RPKI. And so those discussions remain ongoing. I classify that as pending. And then lastly, on community awareness, even at 5 nines, outages occur. All operators have to know how to respond appropriately. Better training, better publicity of RFC 7115. And in fact, what's happening is ARIN's providing more training. These sessions serve that purpose. Other providers on side events are doing that. And that, in fact, that's the hope, and that we're seeing great progress here. So in that sense, I would say that that has made progress, but it remains ongoing. And what you see here is a fairly good dashboard, especially if those pendings turn into complete, we'll see a fairly complete address of the concerns we raised. The only one that lingers out there is the indemnification clause, but in fact, those agreements may be wound up in the whole process of coordinating of the 5 RIRs. So conclusions, in fact, I think this is a nice example. I mean, the government and the NSF funding supported by Homeland Security and NIST really got us engaged in this as academics. And this is one of the few moments where, as an ivory tower professor, I actually see something we can do to actually coalesce some discussion. I think the community's engagement in this has been outstanding. And in fact, understanding the nature of the concerns has been a critical part of this process. But in addition, I think ARIN has made a number of moves that I think are incredibly helpful to RPKI deployment. And so, and I think that they've gone through this whole process with a spirit of openness and engagement that I've always appreciated throughout the entire thing. I think that ARIN has clearly said that they are continue to open to working with the community. So as these concerns, this is a new technology that's going to go through its share of bumps as we deploy. And so my guess is that this is not going to be the last time at levels of detail where we're going to have to engage on ways to make things better. There are some things we said in our reports about possibly waiving the RPA altogether in favor of terms of service that are simply accepted. The use of government procurement processes to drive adoption. I hear from operators, they're saying until a customer demands it, it's not going to pop. It's an issue, but it's not the top of my issues until it gets to that level. If the government actually starts requiring it as one of the requirements for actually bidding on it, that's a nice way to get your customers to start to ask for it. And we did suggest exploration of setting up a separate entity for RPKI. In fact, the RIRs don't have to host the certificate library. It could be anyone. And in fact, in different ways, you could see that developing over time. All right. I'm happy to share what I consider to be good news with the community, and I'm happy to take any questions you may have.
Hi, Tony Talbert, Comcast. So I am interested if there's, you and I chatted a little yesterday, and I think there was some concern that I'd heard on the behalf of one of the open source package maintainers about arbitration. I might have been wrong on that, but you gave me, I thought, an interesting take on why arbitration could be considered a good thing, consenting to arbitration.
So arbitration is part of a family of things we call alternative dispute resolution. And the idea is to get it done faster, cheaper, and with more industry values put in than you would through a court of law. Courts take years, they're very expensive, and in fact, your judge may not know almost certainly doesn't know anything about the internet industry. Arbitrators tend to be taken from people with industry-specific expertise, are jointly appointed with the agreement of both parties, and are commonly used in all kinds of commercial disputes. So for example, commodities tradings always all contracts always include an arbitration clause. So if something, especially if it's a transnational problem, breaks out, you actually have a clear source of law and you all agree, and it's done very, very quickly and done in a reasonable way. And so the hope is that arbitration is generally regarded as a positive thing from the people who advocate for it, as a way to get disputes resolved much faster and much less, with much less demand on organizations in terms of both time and money. And so, this is an issue, though, is that we saw, I think that the question of distributing the validators, the TAL and the validator software has been largely addressed. Organizations that do want to begin filtering and do ROV are required to sign the RPA. And so the questions about the remaining clauses remain. I think the arbitration clause, by most standards, is a very typical one. You see it in securities arbitration of all these different kinds, and is generally considered very successful.
John Curran, President and CEO of ARIN. I just want to say, Christopher, thank you for your work, and it's helpful to have you be involved in sort of coalescing the comments about the use of RPKI services. It's been helpful for ARIN because we hear from individuals. Sometimes it's anecdotal, sometimes it's one lawyer or one technical person's belief. And it's good to have someone who's sort of standing up and scrubbing them on the other side so we can look at what's real. And we have, to the extent possible, the ARIN Board of Trustees has authorized adjustments to how we do our agreements and how we operate. At the same time, we are trying to offer a service that is very different than Who is. And what I mean by that is it has a more natural linkage to how the internet operates or doesn't operate. And we don't want to endanger the registry in the process of providing you the RPKI services you want. We don't want to have a situation where there's an operational problem and we end up with an RIR on the ropes because someone has managed to successfully do a legal attack afterwards against the registry. So we want people to use RPKI in accordance with the best practices to make sure they're using it wisely so you don't have a problem even if there is an issue with the registry. At the same time, we're trying to be as relaxed as possible on the legal side to protect your registry, ARIN. I think we've reached a reasonable compromise. Having said that, we're always open to more input. Also, the ARIN suggestion process is open. If anyone has improvements for the service, submit them. We're happy. We put them on the mailing list and discuss them. So I will say it's been a very productive engagement. It's been good having you, Christopher.
Well,
thank you.
Thank you. I mean, just so you know how this began, NSF called me and said something to me I've never heard or before, never expect to hear again. It said, "We're holding a grant for you." Because they needed someone who, basically engineers would hear legalese and they said, "I don't know what that means." And then the lawyers would look at the actual technical underpinnings, couldn't understand what that meant. So you need someone who's actually trained in both the technical side and the legal side. And so what I did is I tried to go through the community. I didn't take anyone's statements at face value. I tried to get inside the community, and also the community comes from a lot of different points. And so synthesizing together, I engaged with ARIN, other places, and I didn't take anything they said at face value. And the hope is that we got some progress. And as with any technology that implements at scale, I'm sure we're not done with our growing pains, but hopefully we've created a foundation and a dialogue that will allow us to get over having new problems to deal with. We get over these, and now we can focus on the new ones. All right. Seeing no other questions and seeing my moderator lurking on the side, thank you very much.